for courts, for arbitrators, for mediators, for anybody trying to come up with creative solutions for problems that people, organizations, and businesses are facing, it's going to open up all kinds of new possibilities, which I think is a really hopeful thing.
I mean, it's one of the use cases now that's already live and ready to deploy is its persuasive ability. And I've had this experience too outside of crafting judicial opinions, which I don't do for fun or otherwise, but I've had it sort of like help me through some interpersonal dynamics where I'm trying to write an email or come up with a solution, and it will sort of create a position and a perspective that I hadn't thought of before because it's sort of objective in that way. It's not sort of held back by the emotions that you have as an individual or your limitations from your perspective. And it will say, in this framing, both parties to the transaction or whatever would have a shared responsibility. And therefore, you can make the case that it would be more beneficial to do X. And it might be something that I hadn't thought of before. So I could see litigators at trial in appellate courts and judges using it.
Welcome to 2030 Vision, AI and the Future of Law, your go-to podcast focused on exploring the transformative impact of artificial intelligence on the legal industry. We're your hosts, Bridget McCormick and Jen Leonard, and together we'll navigate the rapidly evolving landscape of artificial intelligence, uncovering the opportunities, addressing the risks, and imagining the future.
In each episode, we bring you insightful discussions about cutting-edge technologies, the latest trends, actionable strategies, case studies, and novel insights that help your organization imagine its own future.
Whether you're a legal professional, a tech enthusiast, or simply curious about the future of law, this podcast is your gateway to understanding the profound changes AI will bring to the profession. Join us as we scale education and empower the legal community to thrive in an era of unprecedented innovation.
Welcome to 2030 Vision, AI and the Future of Law. Welcome back, everybody, to 2030 Vision, AI and the Future of Law. I am your co-host, Jen Leonard. I am thrilled, as always, to be joined by Bridget McCormick, President and CEO of the American Arbitration Association, where we talk about all of the fascinating things that are unfolding in the world of generative AI and try to keep pace with it, and also try to share some of our insights and impressions along the way in the hope that it is helpful to everybody in the profession as you're also trying to get your arms around generative AI and the future of law. Today's episode will be our second in a two-part series around courts and generative AI. So we'll talk specifically about judicial use of generative AI for drafting opinions. But before we jump into that topic, as we always do, we'll start with two other segments. Our first is what we call our Gen AI moments, which are the times between our last recording where each of us have used generative AI and have found it to be really stunning and almost magical and very helpful in our day-to-day use. And then we'll share a few definitions that are common in the world of large language models. And then we'll dive into the substance for today. So Bridget, I'd love to hear about your Gen AI moment since our last recording.
Absolutely. It's great to be here. I'm excited for today's conversation. I have to give credit to my Gen AI moment right now to my collaborator, Zach Abramowitz, who built Zach and his firm, Killer List Strategies, have been working with the AAA, like you and your firm, Jen, in helping us think about what dispute resolution is going to look like in the future. And he started getting really interested in Frances Keller, who was the founder of the AAA in 1926. And he fed her books and other articles into a generative AI platform and built a Frances Keller bot that we can now ask questions to about some of the things we're thinking about doing in the future. Frances Keller was fascinating. She was she worked on immigration reform, women's rights, criminal justice reform. In the 1920s, she was an out lesbian who saw dispute resolution in courts as imperfect in lots of ways for lots of people and lots of disputes. And so she founded arbitration, and at the time it was really disruptive. But asking Frances Keller today what she would think about some of the new ways disputes can be resolved is absolutely fascinating, but also lots of fun. So we're going to keep working on it, and Zach's going to keep improving it because we have a 100th anniversary coming up, and I think it'll be a fun tool for our community to play with.
That's really cool. It's like echoing through history. Have you asked the bot anything of interest or received any answers that were particularly interesting?
Yeah, as you know, there's arbitration is a mature form of dispute resolution, and mediation is too. But mediation has been sort of outpacing arbitration in terms of people's interest in it and adoption of it. And asking Frances Keller what she thinks about those trends, and whether there are benefits to mediation for certain kinds of disputes or certain people and certain organizations has been really fascinating. I mean, she really viewed alternative dispute resolution kind of generally as um, a path for peace, like peace in society. And so it's really interesting to hear her how she would think about new ways to achieve more tranquility, more peace. It's really fun.
That's really cool. My example is really lame after that example. But I was reading a book for fun, and the book was talking about it kept referencing this phrase, the plastic hour, which I hadn't heard before. I don't Have you heard of this term?
No,
So it's basically this concept that there are different times in history where there's a convergence of technological forces, social forces, political forces that open the possibility for changing the way structures and systems function. And you have choices to make as a society as to which direction you want to go in. And I thought it was such an interesting phrase, and I hadn't heard it before. And I was working on a speech about kind of the same issue, and with the same tenor. And I wanted to invoke the term, but I wanted to make sure that I wasn't using it inappropriately or that it didn't have some sort of, checkered history. So I used perplexity to sort of research the background. And it's attributed to different people, ranging from Karl Marx to some Jewish philosophers. And actually, a writer for The Atlantic, George Packer, used it a few years ago in the wake of the pandemic to describe us as being in a plastic hour. But it was a helpful way to sort of just quickly do some research, but also verify that it was something appropriate to use. So I thought that that was helpful and interesting. And I love using perplexity to sort of grab articles really quickly. So that was my Gen AI moment for this session.
are you using the Perplexity subscription model or just the free model?
The pro model,
Yeah,
which I think is the subscription one, right?
yeah, it is. Sorry, yeah, that's right.
Yeah, I feel like it's like my streaming services. I have like 10 of them now.
I know. And then keeping track of the logins when you go on new devices is a complication in my life right now. I got to figure out how to have Gen AI help me with that.
That's right. I frequently use ChatGPT for all my IT needs. It's very helpful in that way. I don't know if you use it that way, but like good IT support.
Definitely. Yeah.
So, do we want to jump into a couple definitions for this week?
Yeah, let's do two definitions. Why don't I start by asking you to teach us what attention mechanism means in the context of generative AI?
So, as I understand it, attention mechanism was sort of the breakthrough that led to this era that we're all experiencing now. It came out of a paper in 2017 from the Google DeepMind team, I think at the time, in a paper called Attention is All You Need. And it's a little bit different from the way that we think about attention colloquially. As I understand it and have tried to sort of help myself understand to talk to others about it, it's the equivalent of being able to look at a library full of millions and millions of books. And instead of having to read them sequentially and then draw connections at the end by touching back, the LLMs, the large language models, are able to sort of simultaneously look at all of the tokens and all of the words across all of those millions of volumes of books and make connections over time. So I almost envision like looking at a stack of books and being able to see instantly, this one pulls here and here and here, almost magically, which is what makes it so efficient to draw those connections and be able to predict the next word or token. And that was sort of the breakthrough and the precursor to the release of ChatGPT, which then accelerated our understanding of how to use LLMs that were powered by attention mechanism. Is that consistent with how you understand it?
Yeah, although I confess to feeling like I just barely understand it. I have to say that attention is all you need paper. I have now I so many people talk about it and I have never even attempted to read it and I sort of feel like I should. Have you read that paper?
I have not. I should, for sure, but I have used Gen AI to try to help me come up with analogies to describe what attention mechanism does, and one that it came up with, it helped me with the library example, but it also said it would be the equivalent of sort of having an old school detective go by themselves to a really complicated crime scene and try to jot down everything that they see and then draw conclusions, with having 1,000 detectives on a relatively confined crime scene and all be drawing connections to one another at the same time, and how much more quickly and effectively you would solve the crime, which I thought was
That's
interesting.
Yeah, that's great. I love that analogy. That's super helpful, actually. Yeah.
And definitely, I would have never thought of it on my own. Um, so, Bridget, another definition, another word that we hear about frequently is alignment. What is alignment?
So alignment is the objective, the goal of making sure AI systems behave in ways that are aligned with humans' values, human ethics, and human intentions. It's a pretty, I think, foundational concept in AI safety and ethics, and it's one that you hear people who work on those topics discuss pretty regularly. There is always this concern that AI systems will um, act on their own in ways that are not in sync with human objectives and interests and values. And so AI companies always have a safety team trying to work on alignment. Is that do you think I kind of got it right?
That's how I understand it. And I think it's a good definition to lead into our conversation about judges and courts, whom we trust to sort of uphold our values and interpret people's rights and obligations with one another. Just to kick off our conversation, there was a recent Thomson Reuters report that surveyed court administration and judges and asked for their impressions of generative AI tools. It was a little bit interesting. The results were slightly different from the rest of the profession. They were similar in the sense that, similar to the rest of the profession, the primary sentiment is one of neutrality and sort of waiting to see whether generative AI is actually helpful and useful and ethical to use. But different from the rest of the profession, court administrators and judges were more likely to report that the second emotion was concern, where law firm lawyers, the second emotion was optimism and hope that this could be used in positive and helpful ways. So I thought that that was interesting. Two other things that came out of the report that I noted, the reasons that people most frequently cited in court responses to the skepticism or the concern was first that they were concerned that the first person accounts of litigants before the court and the language that they use to describe their experiences is so essential to determining people's rights and obligations that people were concerned, judges in particular, I think, were concerned about substituting computer language for human language. And the second was that people just are not sure how they should be using generative AI tools in the work that they do for the courts. So, as somebody who has spent a very long time leading a court in Michigan, the state Supreme Court, of course, what are your reactions to those findings?
I'm surprised that 18% of courts report having some training. I have said here before that I think courts are at such a disadvantage just because they rely on public funding, and public funding is a political process for all of their resources, and so AI resources are expensive and scarce and hard to come by for even the most well-heeled legal businesses. And so I feel like courts are at a real disadvantage in trying to keep up and have the resources for their teams to learn how to make use of the tools. The concern to me probably is more of a reflection of that it's just going to be it's just very, very hard for courts to keep up with this technology, given how quickly it's moving and how hard it is to 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 figure out how to use it well. But I don't think that ultimately they're gonna stand by the view that the concern about losing the litigant's voice. I mean, there's lots of room to hear both a litigant's voice and also improve your operations. So I feel like that particular concern will be able to be addressed if the resource issue is addressable. That's the harder one to be.
Yeah, agreed. And we've talked in the past about our shared concern about the pace at which the private sector will move with these tools compared with public institutions generally, and courts especially.
Yeah, you and I have both. One tool that some courts are using. I don't know if we talked about this in the last episode, but the Clear Brief AI product, which I know you've met Jackie Schaefer, who's the founder of that company, and that particular AI product focuses on the facts, like on the record, and it's a great tool for courts. And Jackie has had really good luck with the few courts that are willing to use it. Seeing what a huge benefit it is for their operations. So when more and more products are out there that courts can see how they make their operations better and smoother and faster, I predict we'll see more and more comfort level with the technology.
Yeah, and Clearbrief's a great example too of an early emerging tool that makes use of the promise of all the great underlying data that we have in the profession, because it seems like in a lot of other spaces, we're still grappling with data and how to package it in a way that can be useful for LLMs. But Clearbrief really uses the court's dockets and information, as I understand it, right, and can support both courts and litigators. Is that accurate?
Yeah, that's exactly right. It's to the extent you're willing, you can share it among all of the parties in a particular dispute, because you can all kind of cross-reference your the work that it does is it pulls all of the facts and then shows you where they're pulled from in the record. So I always think, like, there are so many places where litigation could be less adversarial, right? Like if we could all agree at the front end on where the facts are not in dispute and where they are in dispute, it would really save us a lot of time and energy to be able to focus on the places where there's going to be room for people to disagree. And so it feels to me like one of those tools that could really, really bring some efficiencies to the adversarial process. But one judge on the 11th Circuit made some news earlier this summer in a concurrence. Judge Kevin Newsom, I think Kevin is his first name. I hope I got that right. And he used ChatGPT to try and determine ordinary meaning in a statutory interpretation case. Can you walk us through what Judge Newsom did there and why it got so much attention?
Sure. So the case was an insurance dispute, and the ultimate holding or part of the holding hinged on whether an in-ground trampoline qualified as landscaping under the insurance law at issue. And Judge Newsom was consulting dictionaries, working with his law clerks, trying to figure out if a trampoline would be considered landscaping, and couldn't find a definition or an understanding of the trampoline that was helpful. So he's sort of in jest, and he talks all about this in the concurrence, which is lengthy, about how he came to consult ChatGPT, but he actually found ChatGPT to be particularly helpful in resolving the question. And what he actually asked ChatGPT was, could an in-ground trampoline be considered landscaping? And the AI answered that yes, this is a quote, yes, installing an in-ground trampoline can be considered a part of landscaping. It's a deliberate change to the outdoor environment, often aimed at enhancing the overall landscape and usability of the area, end quote. So that is the response that he got from ChatGPT. And he talks about this in the concurrence and how helpful it was, and how he viewed it to be a more comprehensive version of how this word would be used in common parlance. And that's something that he prioritizes in his opinions. So it caused a lot of buzz. He was very transparent with his use of ChatGPT, and he also shared the prompts and the responses in his concurrence. And of course, it stoked a lot of conversation across the profession. And a few outlets, law.com in particular, surveyed some other judges who are at the cutting edge of using technology and asked them for their thoughts. And the thoughts ranged from really celebratory and commending Judge Newsom for being so forward thinking, and showing the profession how it could be used, to other judges who were less certain that LLMs are appropriate, in part because of the biased data underlying their training sources, and in part because of the limitations and the hallucinations that LLMs can produce. So I will tee it all up, but I have no experience being a judge. You have tons of experience being a judge. So I'm curious what your reaction was to Judge Newsom's approach here and some of the responses across the judiciary.
Yeah, I thought it was fascinating. And I'm really glad he did it and started the conversation. I feel like it was an important conversation starter, not only about the ways that this technology might be useful in helping figure out ordinary meaning of terms in regulations or statutes or even constitutional text, but more than that, how judges think about those subjects. I mean, you read a lot of judicial opinions where there'll be a majority opinion and a dissent, and both sides of the opinion are super confident that they have determined the correct meaning of a particular word. And it always seemed to me like, obviously, it's a really hard question if really smart people using, who have the same training, are coming to different conclusions about what this particular term means. And one carries because it's a majority rule industry, but obviously it's the tools that judges have are imperfect, right? So dictionaries is a typical one judges look to, and there are lots of critiques by scholars that judges can cherry pick dictionaries depending on the particular outcome they're looking for. I'm not saying that those are fair critiques. I'm saying that those are critiques that you hear pretty regularly. And I think that if you asked people who didn't go to law school to read a judicial opinion, and where dictionaries were used to define a term that people sort of had an intuitive sense of what the term meant, they would be scratching their head, and they might say, well, we kind of know what that means, and here's what it means. And this Judge Newsom's use of the technology felt to me like the kind of opinion that a person reading it who didn't go to law school might say, yeah, that actually makes sense. And that I can accept that decision because it actually rings true with me. It evokes this earlier. There was like sort of 5 to 7 years ago. There was this move by a number of courts, and the Michigan Supreme Court was one of them. In an opinion drafted by one of my colleagues, Justice Brian Zara, where courts were using corpus linguistics, which is a method of linguistic analysis that uses large collections of texts, not legal text, just texts, called corpora, to study patterns and usage and structure of language. In a way, I feel like corpus linguistics in judicial decision-making was the precursor to ChatGPT in judicial decision-making. There's some important distinctions. The texts that are in corpora are knowable, so it's totally transparent. Unlike we don't know all the training data in LLMs, and obviously the technology is different. It's statistical analysis in corpora, and it's neural networks in LLMs. But there were, in addition to the Michigan Supreme Court, the Utah Supreme Court issued at least one, but I think more than one opinion using corpus linguistics, and Justice Breyer did it in one opinion. I think the thinking there was, it's a bigger set of texts to help figure out what a particular term means, and we can actually, by looking at the way normal people were using language in whatever the relevant period was when a particular statute was passed, we can get closer to what ordinary people would have understood the term to mean. And I was persuaded that it was a useful tool at that time. And so I think I'm similarly persuaded that this technology is at least another tool that judges could, and in some cases probably should use transparently, again, telling their readers and colleagues what they used and what their prompts were, to help understand terms that are not perfectly clear. I don't know. It'll be interesting to see if other judges take up Judge Newsom's invitation. I think that's how I read it, was an invitation to start at least thinking about the ways in which this technology might help us with understanding ordinary meaning.
Yeah, I had not been familiar with that movement. So thank you for introducing it, because it does sound very similar. It sounds a little bit like a slightly more laborious way to do it, but like you said, a little bit more transparent, but similar to LLMs. It's really quite fascinating.
Yeah, I have to. It's all gonna get more and more interesting too. I do think that the ways in which these LLMs can make decisions is going to be something we're all going to be continuing to talk about. I think I don't know if I mentioned this to you, but so many now appellate section, educational programs are focused on this topic of when is it appropriate for generative AI to, be used by courts and by judges. And so I think it's a topic that we're gonna. This is not going to be our final episode on this topic. I feel like we'll be coming back to this one. And I recently got to talk to Adam Unikowski, who is a partner at Jenner, and writes a really interesting newsletter that I encourage people to go look at. And he fed on this topic of he's an appellate litigator, like a fancy one. He practices in the U.S. Supreme Court. He practices in federal appellate courts and state Supreme Courts. Full disclosure, he appeared before me once in the Michigan Supreme Court, although I didn't remember that when I talked to him about his work. In this context, he reminded me afterwards, and he did a great job. But he did a great experiment, a really interesting experiment, where he fed all of the merits briefs from all of the cases argued in the U.S. Supreme Court this term into Claude Opus. That was the most advanced model when he did his experiment. And he asked Claude to write a 3-paragraph opinion deciding each case. And in almost every case, it wrote an opinion consistent with the way the U.S. Supreme Court decided the case, and it did an excellent job. In a few cases where it didn't write an opinion consistent with the U.S. Supreme Court, Adam himself was persuaded by Claude's opinion more so than the U.S. Supreme Court's opinion, and they were cases where it was a close question and justices disagreed. But what was even more interesting was he went beyond that and then asked Claude to come up with a different solution to a particular legal problem in a particular case that neither party suggested. He said, we come up with another way, a new test that neither party suggested for how we could decide this hard legal question. And it's fascinating what Claude came up with. And Adam Unikowski, who again is like a very accomplished appellate lawyer, said, Claude is absolutely capable of doing the work of, the fanciest appellate law clerks we have right now, and maybe even a justice. So, that's not saying that it doesn't still have some of the problems we've talked about many times in the course of this podcast. But it is a stunning experiment he ran very quickly, very easily, that really tells me there are going to be more and more uses for this technology for courts, for arbitrators, for mediators, for anybody trying to come up with creative solutions for problems that people, organizations, and businesses are facing. It's going to open up all kinds of new possibilities, which I think is a really hopeful hopeful thing. I'm excited about it.
That's really cool. And I mean, it's one of the use cases now that's already live and ready to deploy is its persuasive ability. And I've had this experience too outside of crafting judicial opinions, which I don't do for fun or otherwise, but I've had it sort of like help me through some interpersonal dynamics where I'm trying to write an email or come up with a solution. And it will sort of create an argument, or not even an argument, it's not a dispute, but a position and a perspective that I hadn't thought of before. It because it's sort of objective in that way, and it's looking at, I mean, I'm anthropomorphizing it now, but it's not sort of like held back by the emotions that you have as an individual or your limitations from your perspective. And it will say, in this framing, both parties to the transaction or whatever would have a shared responsibility, and therefore you can make the case that it would be more beneficial to do X. And it might be something that I hadn't thought of before. So I could see litigators at trial, in appellate courts, and judges using it in just the way that Adam's suggesting.
Yeah, I agree completely. I mean, one of the things that it does well, that everyone will say this technology does well, is idea generation. We do a lot of idea generation at the AAA around hard questions and hard problems. But now we always have the help of our LLM friends, and it is just really stunning how many ideas it can come up with and how quickly. And so it sort of makes sense that in trying to decide a hard question that two parties disagree about, it's going to be an excellent new tool in thinking of new solutions that nobody has brought to the table. So I really do think there's an exciting future for this technology and resolving disputes.
Very cool. And, I think it was clever that Judge Newsom used a concurring opinion to sort of lay out how he used this. It didn't impact the ultimate holding, but as you said, was an invitation to think about how LLMs could be used. And on the heels of all the stories about it, I met a judge at a conference recently, and I asked him because I was then curious about judges using generative AI in their opinions. And we talked about whether judges would need to disclose that they are actually using Gen AI. And people in the conversation had different perspectives on that. One perspective being that you would have to disclose usage so that appellate courts would know when the human judge created content and when a Gen AI created content. It all makes me wonder, though, if we'll look back on this era as sort of like the dawn of all of this, and it will become so infused in what we do that it will seem sort of laughable down the road that we thought we would have to disclose things like that. But I wonder what your perspective is on that topic.
Yeah, I think I understand the judge's reaction that you spoke to, even if I don't share it. It is important in appellate litigation for the appellate court to have the information that the trial court had when it made its decision, if it's going to be able to evaluate it properly. But I'm not sure that it makes sense that disclosing your use of the technology in the course of your decision making as a trial judge really follows from that. I mean, trial judges don't, record what work exactly their law clerks did, to help them with coming up with a particular decision in a case. They don't disclose, what previous, work of their own that they might have done in some other context, and they're using it for this particular case. They've already researched this question in the context of a different case. They don't disclose, what Westlaw or, other legal research tools that more and more have this technology built into them. So I don't know that I agree with the conclusion, even though I understand where it's coming from. I think your prediction is correct that, I don't know, 5 years, 10 years from now, we should replay this conversation, and it'll seem a little naive at the front end of all of this.
Yeah. I think it's a great note to end on because it sort of touches back to that Thomson Reuters survey about education and literacy, because I could see some places like where Judge Newsom is outlining how he used it for it to be really relevant, right? If it's something that the case will hinge on and you want to know where the definition came from or where the concept came from. But to your point, these tools will be infused in a lot of the day-to-day tools that we use. And I can imagine appellate law clerks drafting opinions and workshopping the language and then plugging it into the opinion without the judge even knowing, in the same way that they would review a clerk's writing anyway and not know, exactly how they came up with the words that they chose, but will make edits according to what they want to edit. But all of that requires a lot of literacy and training and conversation. So it'll be really interesting road ahead.
And I want to add one more point. I guess my instinct is in favor of as much transparency as possible in this like liminal period we're in. I sort of feel like we're in this in between moment. There's going to be a new normal when this technology is in all of our iPhones and all of our laptops, and it's just kind of it's our partner all the time. But I think along the way, and especially for institutions like courts or, even in alternative dispute resolution, the more transparent we can be with the people we serve about how we're using the technology is going to be valuable, whether it's required by appellate courts or not. I think it's going to be valuable to building public confidence in what we do.
Yeah. Well, this certainly won't be our last conversation about courts using generative AI. There are lots of interesting dimensions to it, and we're grateful to Judge Newsom for getting the conversation moving and advancing it. And we'll look forward to future conversations as new issues emerge on using generative AI in the judicial and court system. Thank you so much, Bridget, for sharing your thoughts.
Absolutely.
We'll see you all next time on 2030 Vision, AI and the Future of Law. Take care. Thank you for tuning in to 2030 Vision, AI and the Future of Law. If you enjoyed this episode, please subscribe to our podcast and leave a review. Stay informed and inspired as we continue to explore the AI-driven future of the legal profession. We'll see you next time.